Hi everyone. So today I want to cover the topic of unlawful presence and the permanent bar. Before I get into this, if you have any questions or you want to schedule a consultation, head over to our website at carboneattorneys.com. We have a button at the top of our website. You just click it, fill it out, and we'll get back to you. Unlawful presence. So I've covered this before. Now, what this is if you're in the United States and you don't have lawful status, if you don't have a visa, if you don't have a green card, you don't have permission to be here, you're accruing unlawful presence every day. Every day that goes by, you accrue unlawful presence. So once you hit a certain amount, 180 days, you trigger what's known as the 3-year bar to admission. If you are here for a year, you trigger the 10-year bar. And then the topic of this video is the permanent bar. So if you've accrued a year or more of unlawful presence, you've left the United States, and then you attempt to re-enter, whether successful or not, you've now triggered the permanent bar. Another way to trigger the permanent bar is if you have an outstanding removal order and you depart the United States and then attempt to re-enter. Again, you don't have to be successful. So if you show up at a border crossing or at an airport and you're denied admission, that counts. So why do we call it the permanent bar? The immigration statute actually does not use the word permanent, but among colleagues and within the field of immigration law, it's known as the permanent bar because the hurdles that you have to overcome often make it almost impossible. So it got the name permanent bar because, for the most part, one of the biggest hurdles you have to overcome is if you triggered the permanent bar, you have to spend 10 years outside the United States. This is not a joke. You have to leave the United States and you have to spend 10 full years outside of the United States. Now, if you have a family, if you have a life here, if you have kids, a job, a business, if you've developed a life in the United States, spending 10 years outside isn't really typically an option for most people. Now, with the 3 and 10-year bars, there is a waiver available. Not everyone qualifies, but if you do and it's granted, the government will waive the bar and you can be admitted into the United States. With the permanent bar, there is no waiver available. So what that process looks like is you spend 10 years outside the United States, and then once that period has expired, you would then apply using the I212 form, and you'd submit that asking for permission to re-enter. Now, the catch here with the I212 is that it's completely discretionary. So what that means is that you could meet all of the requirements, present an admirable case that you deserve to be admitted into the United States, and the immigration officers reviewing your case can deny you on discretionary grounds. Meaning, if they think, in their opinion, that you do not deserve to be admitted, you will lose. And that's it. And your case is over. So the permanent bar, it's not technically permanent, but given the nature of these circumstances, especially the 10-year waiting period combined with the discretionary nature of the I-212, can certainly make it seem permanent. Now, people have gotten I-212s approved in the past, of course, but it's a very difficult process. Ultimately, if you've triggered the permanent bar, you want to speak to an immigration attorney immediately. An immigration attorney will be best suited to walk you through this process and, potentially come up with alternative scenarios to try to overcome the permanent bar in other ways. If you qualify for certain relief in other regards, you might be able to circumvent the permanent bar, but that's not always available to everyone. So that's it. That's the permanent bar. If you like this video, if you want to see more, please like, subscribe, double tap, and as always, I'll keep making these videos.